We will call to order the Board of Election Commissioners for the City of Chicago, constituting ex officio the Electoral Board to hear and pass upon objections to the nomination papers of candidates for offices to be nominated or elected at the March 17, 2020 general primary elections. Good morning, my name is Marisel Hernandez. Seated to my right is Commissioner Kresse, and to my left is Commissioner Jonathan Swain. Next item on the agenda are the Rule 20 hearings, and today we have 20 EBWC-021 William Kelly versus Richard Gordon, Board Committeeman, 42nd Ward, Republican. And we have, can you state your appearances for the record?
For the record, Alan Spitz appearing for the candidate.
For the record, Lord Rahutsky appearing for William Kelly, petitioner, objector. By the way, just Your Honors, I am getting over a cold and I have asthma on top of it. I may have to excuse myself. It's not contagious, but really annoying.
Yes, I understand. Yeah, I understand. Okay, so Mr. Spitz, this is your supporting motion. Is that correct?
Correct.
Is it button on green, the light?
It's on.
Yes.
Okay. I'll let you proceed.
Good morning, Commissioners. This is the candidate's Rule 20 motion. The procedure that brought it before Your Honors is that the candidates filed a motion to strike the objection. There were 4 clauses stated as in my Rule 20 motion written procedure. Divided into 2 factors. Number 1 is the bad faith allegation against the objection, and number 2 is the verbiage in the objection. I would disagree, and I believe that the hearing officer was incorrect both on the substance of the law and in the procedure that he used to bring the matter before Your Honors and to write his final decision. The candidate raises a bad faith objection in his motion. And that's based on the fact that the objector did not at any time review the records of the board to determine whether the signatures are good or not on the petition. And as a result, 87 objections were filed against various signatures. There were only 137 signatures filed. All those objections go as to proper person. And there's no other objections as to any other cause, even though in their objection, they do state other objections, but they didn't check any boxes, either haphazard or part of my bad faith objection to their petition. And I don't know, striking petitions just as improper person, you don't subject any other line to be struck. Does that mean if they're registered at a different address outside the district, it still counts, I assume? These petitions were circulated by 3 people, the candidate's former wife, and the former 42nd Ward Republican committee person. The signatures are good. The objectors never challenged, never reviewed these signatures prior to challenging them. I also point out that on the first page of the objection, or first page of the challenges, there are 10 lines. There are only 5 signatures submitted. 3 lines were checked where there's no signature. Another instance of bad faith is they did not object to a signature where there was no address even given, but they said proper person only. The objector is one of the people who was objected to and in part facilitates then this proceeding today. She was offended that her signature was challenged as a forgery. I believe in normal circumstances this would be sufficient to send this to a records check to determine whether or not this is a good faith or bad faith objection. There's one little wrinkle, though, that the candidate didn't file enough signatures, though, to make the minimum. But I don't think that should be the controlling factor here. I believe it must be determined first whether or not there's a good faith objection or a bad faith objection filed to the petition. That is normal procedure. We first check to see whether or not the objection is filed in good faith. If it's not filed in good faith, then we go no further. We don't check to determine whether or not the candidate has sufficient signatures or not. In most cases, this would not be a factor because the objection would state that the candidate didn't file a minimum number of signatures. X number of signatures are required. The candidate only filed less than X, 1 minus X. In this case, that's not one of the objections in the objection that the candidate didn't file the minimum number of signatures. So I believe this is in many ways a unique case. And the procedural objection is that even though the hearing officer agrees with the motion to strike, that the objection never stated there was a minimum number of signatures missing, he then counted out the candidate anyways. I don't believe he has the authority under case law, under the statute, to count out a signature if there's no allegation that they didn't meet the minimum. You've got to meet the minimum and state that in your objection in order to be counted out. Absent any objection, even if you file less than the minimum number of signatures, you would be on the ballot. So absent an allegation that the candidate didn't file a minimum number of signatures, there should not be a count out. We should go then to the recapitulation, the sheets. And I'm indicating because this is a bad faith objection, we should never get to a records check. We should do a sampling. I'd say sample all 87 signatures to determine if any of those objections are valid. If none of them are valid, we don't want to encourage bad faith objections here, and we shouldn't go forward. I know in the Delk versus Horse case, there was a bad faith allegation. I was involved in that case some 20 years ago, and they went to a sampling, 35 signatures, and only one objection was found valid. I believe if similar was to take place in this case, the same results would be found. I allege numerous times that the candidate did not check the records. I filed a FOIA request, which I attached to the Rule 20 motion, and it was filed December 19th. I still haven't had a response from your board as to whether or not your records show that they actually did inspect the records, and that would only confirm the information I have that they did not inspect. And speaking to the objector himself, there's no indication that he did actually check or have any of his agents check these records. So that's one prong of my motion 20. The other prong is I don't believe the candidate ever stated the office to which they're objecting to. The prayer for relief must be specific and must state the objection in totality. The hearing officer in this matter in part agreed with me because he could not find the office contained in the objection. He had to look to the candidate's petition to determine what office was being objected to. I believe the objection stands on itself. The four corners of the objection was all that he could look at to determine what office. When this was filed, I attached the receipt from the county clerk. They had the wrong office on their objection. They said Democratic 42nd Ward Committeeman. This is the Republican 42nd Ward Committeeman. Those are two different offices, and the case law does not support the objector's position. We have two cases, one cited by the hearing officer, and the other one I put in my objection, Novak versus Miller, where there was a typo. This is an omission, this is not a typo. The office was left off. It says Ward Committeeman, 42nd Ward Committeeman. There are two of them. There are three of them. There's the Green Party, in fact, has a Ward Committeeman. And in the Wolin case, is a misnaming of the office. I don't believe this is a misnaming. This is an omission of the name of the office. A misnaming would be, instead of saying committee person, which is now the law, they said committee man. That's a misnaming. Leaving out an omission as to an integral part of the office would be enough, in my opinion, to also strike the objection. So based on those reasons, I'd ask that the Rule 20 be allowed, that the hearing, the matter be sent back to a sampling to determine whether or not there's a bad faith objection, and then we can go forward from that. I asked to make a complete record before the hearing officer on my Rule 20, and I was denied the right to call the objector to confirm my allegation of counsel. In part, confirmed it by saying that she didn't check and she knows nothing of whether or not the objector checked. Also, the candidates, the objector's wife is his attorney, so I believe that there should be some knowledge, or at least a way to communicate with the objector to confirm this. But it's our allegation they never checked, and I believe the board's record will confirm that once the FOIA request is completed. Excuse me 1 second. I'll stand on my statements. Thank you.
No more questions, Ms. Litchfield?
Yes, Your Honor. The hearing officer's recommendations and findings were absolutely correct. In the objector's objection, we state that the nomination papers contain less than the 433 validly collected signatures of qualified and duly registered voters of the 42nd Ward of Chicago, State of Illinois, et cetera, and then the second part of it is separated by a comma clause, as is set forth by the objections recorded in the appendix recapitulation attached, hereto incorporated herein. So we do state that the candidate has less than 433 validly collected signatures. We do make it dependent, clearly on the appendix recapitulation. The hearing officer, the opposing counsel has made this bad faith allegation, and I think that the allegation of bad faith and the shotgun objections is in bad faith. In fact, the opposing counsel in the previous hearing said this. He said that if the objector's petition goes to record examination, the candidate will be off the ballot. Why? Because the candidate did not file enough signatures. The candidate only filed 137 signatures. Whether they're valid or not, we don't know. We've objected to some of those signatures based on the signature being a forgery or not being signed by the proper person. That's a factual determination that can only go to a records examination for determination. This idea that that they've somehow checked all the signatures and they're good, that doesn't help Your Honors make a decision about the factual issues here. You would normally have this go to a records examination, have the signatures checked, have the boxes on the appendix recapitulation sheet checked, and then the signatures that are remaining would be counted up. Regardless of whether those signatures are sustained or denied, the candidate only filed 137 signatures. So that is why the hearing officer said, okay, not that this should not go to a records examination, but it would be a waste of our time and resources because the candidate only filed 137 signatures. The grounds for bad faith are kind of bizarre here. So the grounds are that that the objector did not somehow mark enough boxes on the recapitulation sheets. And the opposing counsel has already agreed in the previous hearing that the absence of marks on the recapitulation sheet is not in and of itself a basis for fraud and false pleading, and we agree with the hearing officer that the candidate has failed to meet the burden of proof to sustain a fraud claim. In addition, Your Honors, this bizarre claim that somehow because I did not personally do a binder check or that the candidate had surrogates do a binder check is, again, not in and of itself, does not indicate any fraudulent intent or bad faith on the candidate, on the objector petitioner's part. So all that is just bizarre. It's because he wants to avoid the records examination and go to a sampling because that's the only thing that can save his candidate who failed to even file the basic signatures. He didn't file 433 signatures. He filed 137 signatures. So they're trying to avoid the records examination and just go to a sampling because that's the only way his candidate survives. So this claim against the objector petitioner is made in bad faith. So, in other words, 1, the candidate did not file 433 valid signatures. 2, the candidate filed 137 signatures, whether they're valid or not. The paragraph 6 of our objector petition about the signatures not being signed in their proper person or whether the signatures are a forgery is a factual-based issue, can only go to record examination. If Your Honors would like a record examination, we're more than happy to submit to one. But the hearing officer rightly recognized that that would be a waste of time and resources because there are only 137 signatures. Secondly, Your Honors, the 2 other claims that are basically outlined in the objector's petition, the motion to dismiss, have been argued previously, and the hearing officer rightly cited the proper case law. Does not say anywhere in the statute that that we need to include the party affiliation. It says, one, that the petition shall give the objector's name and residence address. B, state the nature of the objections to the certificate of nomination or nomination papers. State the interest of the objector, and state whether relief is requested of the electoral board. No party identification is required by statute, and then the hearing officer cites Wallen versus Jacoby. So that is the proper case law. The cases that he cited were mentioned in the previous hearing, and they were discounted by the hearing officer with good reason. Secondly, our prayer for relief is very, very clear, with or without the party identification. And the hearing officer has already gone through that analysis, and the analysis is correct. And fourthly, and I mentioned this in our response to the opposing counsel's Rule 20 request, is even in the candidate's own petition, he lists on the top of the petition the office he's seeking as ward committee person in the City of Chicago primary petition. Does not mention 42nd Ward or Republican, and that's at the top of the candidate's petition. Now, elsewhere in the petition he mentions those things, but the issue is the Board of Elections has properly identified the candidate at issue here as Richard Gordon. The Chicago Board of Elections has properly identified Richard Gordon as a candidate for committee person in the 42nd Ward of Chicago, with or without the party identification, and the hearing officer ruled properly on all of these bases. Do I agree with everything in the hearing officer's report? No, not 100%, but I would say that his findings were proper, and the case law that he cited is proper and controlling in this case. Thank you.
Mr. Lester, would you like to comment? And I think one of the things I'd like you to comment on is the ability of the board, whether it has the authority to determine whether there are insufficient signatures, and does that have to be raised as an objection?
Well, if it's going to be a standalone cause of action, but what we have in this case, which this is something that has been previously found to be within the hearing officer's discretion, and I'll show how it works in both directions. You have a claim that paragraph 6 is surviving a motion to strike and dismiss. It challenges whether signatures are genuine. There are the individual check marks that were lodged against 63.5% of the signatures in the petition. And so we have jurisdiction of the case. That means the proper procedure is sent it to a records exam. At that point, it's very common that a hearing officer will make an inquiry to make sure that the records exam is actually necessary. And in this case, the wholesale number of signatures filed is too small, so it would just be an administrative waste really of our resources. We have a lot of other cases that need the records exam. So the hearing officer informs the staff we don't need the records exam on this one, because he can look to the record. Remember, the petitions, the original nominating petitions, are official part of the case file. They are the evidence in the record. The hearing officer looks to that and sees the deficiency. On the flip side of the coin, what sometimes happens is we receive an objection, and the hearing officer might notice, or it might be raised by one of the other parties, but the hearing officer sua sponte may notice that there's not enough objections. Even if 100% of the objections are ruled in the objector's favor, it still would not bring the candidate below the minimum. And in a situation like that, again, we would not send that to a records exam. The hearing officer may sua sponte say, I'm going to dismiss this objection, because even though it's in good faith, even though there's no motion to dismiss filed, I'm making a finding that even if 100% of the allegations are true, no relief can be provided. And so that has happened many times previously with this board, and I do believe that's in the hearing officer's discretion to find that. And remember, that's just the hearing officer making the recommendation, so it really is your job here today to determine if that recommendation is correct. But I certainly agree with it. In this case, there are line-by-line objections, but the candidate doesn't have enough signatures, and we don't need to go to a records exam to find out that the candidate has even fewer signatures.
And with respect to the objection concerning bad faith and the identification or failure to properly identify, fully identify
The office.
the office?
Well, first I'll address the legal issue of the allegation that the office is not identified in the objector's petition. I'm looking at the objector's petition right now, and paragraph 2 does say that it's filed against the nomination papers for the office of board committee person of the 42nd Ward of the City of Chicago. That's in paragraph 2 of the objector's petition. That also appears in paragraph 3, paragraph 4, and I'm just going to skip down. It's also in the prayer for relief, very specifically the 42nd Ward committee person for the 42nd Ward of the City of Chicago. Section 7-10I of the election code identifies the office as ward committee person. That is the office. Those offices exist for different political parties, but the actual name of the office is ward committee person. The election jurisdiction is 42nd Ward. The political party affiliation in this case is Republican Party. The political party affiliation is not an element required by section 10-8 of the election code when it comes to pleading the objector's petition. There's just, I must agree with the objector's counsel here, that that's just not a requirement, neither in the express language of the statute nor by any case law. There is case law in Woolen versus Jacoby, which was cited by the hearing officer. The objector used the term commissioner to object against a candidate who was running for the office of trustee. And so there, you had the complete wrong office, which I think is a little more egregious than failing to put the political party affiliation while still having the correct office. So I do agree with the hearing officer here that that's not a fatal pleading deficiency. Frankly, not even a deficiency, because there's no requirement. There's a second part of your question.
Yes, that was relating to the bad faith.
So with bad faith, this is not the kind of objection that jumps off the page. With 87 objections lodged against 137 signatures, that's just 63.5% of the signatures have been objected to. The bad faith objector's petitions that sort of scream it just looking at the page are those that rejected 90, 95, 100% signatures. So here the hearing officer would not be suspicious just looking at the number of check marks. They appear to be random, we don't know. From that point forward, the case law does allow the the candidate to request an inquiry into how the objection was prepared for the sole purpose of finding if there was actually an inquiry. There apparently has been a FOIA request, and not for our logs. I'm not sure whether we've received a response on that, but what I would point out...
I think Mr. Spitz stated that he has not yet received a response to
Correct.
his FOIA request.
What I would point out in that respect is that whether or not the name of this objector appears on that list is not conclusive. It does not have to be the objector himself or herself who comes down to review the signatures. Somebody should to make this a good faith plea. There are also other ways, however, that the signatures could be checked, whether it's a door-to-door process or comparing signatures from a petition on this year's cycle to somebody else's petitions from 4 years ago, comparing the names and addresses. So none of that is conclusive. What you would usually do is question the objector, or at least question the team that prepared the objections for the objector. But we've long since passed the deadline for subpoena requests, and there has not been one submitted to produce any witnesses or documents in that regard. So that issue's been waived, I say, by the candidates in this case.
Just to clarify, counsel, so, for example, signatures could be objected to on their face. So if, like, every signature was apparently, visually compared, and you can see that they were signed by the same hand, you could object without having to look at the records.
In my personal experience, I have certainly looked at nomination papers where you can see things.
On the face of the papers themselves, you can make the
common
objection.
authorship, and you could in good faith say, there's no way these signatures are all done by individual people, and I'm going to object to that in good faith, because looking at them in my I'm not a certified handwriting expert, but I've looked at a lot of petitions.
Right,
It's possible.
okay.
If I may
Can I
respond?
clarify one thing? You said that the time for subpoenas is passed, and the way that you did, the way that you would do an examination of bad faith, you would go and you would have an examination of the objector, the team that did this to determine whether it's some sort of examination, cross-examination, to figure out whether or not it was,
Correct, and again, the reason for that is that our board records, the sign-in sheets for who's come into the public viewing room to compare signatures, that's not conclusive on the issue. Even if we don't see the name William Kelly, he may have had someone else do that process.
just to clarify the point, there's a need for subpoena for anyone on the team. Is there any need for subpoena for the objector himself?
I suppose a notice to produce, but I mean, we don't have, we're not bound by the rules of procedure, so I'm not so sure that we can compel a party to appear absent our power of subpoena.
I mean, it strikes me as odd, considering that they objected, filed an objection, that we have to subpoena them to show up to keep the family close. That just struck me as odd, that's all.
The objector was present at the hearing, but the hearing officer refused to call him. I asked to call him as a witness, and the hearing officer said no.
That's not true. If you want me to address it, I will.
Yeah, well, please.
But the petitioner objector was not present. He was in the hallway, down the hall, but he wasn't in the hearing room. He never was. And he wanted to have someone drag the objector in and put him under an oath. He wasn't even in the hearing room. He just wanted to drag him out of the hallway. I'm sorry, it was kind of inappropriate.
He was standing outside the door, and he made himself known to me prior to the hearing that he was present. He could have been called easily. It's their objection. I believe, though, counsel basically has conceded the point that they didn't look. I made this.
I never said that, and in fact, I actually said the opposite.
I made the point on numerous occasions that they did not do a records check. We have no response from objector's candidate here that they did look. The candidate, the objector, in fact, told me he didn't look. That's not part of the record. I wasn't sworn as a witness, but if we go forward, I'm sure that will be confirmed. So I believe, can you have a good faith objection if you check boxes and don't do a records check prior to it? I believe not.
I think we have heard sufficiently. Are there any further questions? No? If not, and I thank you both for your arguments. Is there a motion to deny the motion to strike as to paragraphs 6 and 12 of the objector's petition and to grant the motion to strike as to paragraphs 5, 7, 8, 9, and 10?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. Thank you.
Thank you.
And we will be ruling, just if you want to stick around, we will be ruling then on the final hearing officer's report in just a couple of minutes.
Do you consult in private that we should step out?
Oh, no. It's open. You're welcome to stay and get a copy of the final decision, or we can email it, whatever we do.
Sent by mail as the statute requires.
Send it by mail.
Thank you.
But we can
We
also
will give a
hand-
courtesy copy by email.
Yeah, okay.
Thank you.
Next on the agenda are certain requests for subpoenas. The first case is 20 EB-RTA-019, Andre Thapedi versus Ricky Gandhi, representative in the General Assembly, 32nd Representative District, Democratic. I'll turn it over to you, Mr. Lasker.
Misplaced my memo. Here it is.
So in this In this matter, RGA 19, the objectors requested 7 subpoenas for candidates' various employment and release records in Washington, D.C. in support of what is the sole allegation in the objector's petition that the candidate's not a lawful resident of Chicago or the legislative district. So the hearing officer is requesting, they're recommending that the subpoena request be denied. First of all, the subpoena request was filed on December 23rd in the afternoon, whereas under Rule 19C, the deadline was December 21st. And that's the first issue for denial of the subpoena request. I'd like to address that. This board does have a history of strictly enforcing that 5-day filing deadline, which is a rather generous deadline actually in the grand scheme of things with these expedited electoral board cases. There have certainly been times when the deadline has been extended by this board when good cause is shown. We had an interesting case last time where evidence surfaced about the rehabilitation affidavits involved with that case, and that was much later on in the proceedings, but no one could have known ahead of time that there would have been that issue arising. Here, the entire objector's petition is based on the allegation that the candidate's not a resident of the district. So the objector should have known from day one that these are records that they're going to need to see. There was no request for an extension of the deadline. The hearing officer even sent an email to the parties. It was a case status, some dates, and in that email even expressly reminded the parties ahead of the December 21st deadline that that was the deadline. Yet it wasn't until 2 days later. So for that reason alone, I think the request should be denied. The hearing officer also gets into the merits a little bit to point out that in dealing with a residency matter, employment records somewhere are not really usually very strong evidence for not dispositive on residency. And I just remind this electoral board if it even needs a reminder that former Mayor Rahm Emanuel had a residency objection filed against him. Actually, 31 residency objections filed against him when he ran for mayor the first time he was serving as chief of staff in Washington, D.C. The mere fact that he had moved temporarily out of the city was not enough. So anyway, on the merits, I think the request is a little overbroad, but certainly on time as well.
Any questions? If not, I agree with your opinion. This subpoena request was not timely, and therefore, is there a motion to deny the objector's subpoena request?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. The next subpoena request is 20 EBWC-005 with a related case, 20 EBWC-003, Veronica Ramirez versus Daniel Laspada, Board Committee Person, First Ward, Democratic. Mr. Lasker.
In this matter, the objector is requesting 5 subpoenas for 5 of the petition's circulators. The candidate has opposed 4 out of the 5 subpoenas. The hearing officer is recommending granting all 5 of the subpoenas. I do agree, but I think it's important that we discuss that your motion and your approval of the subpoenas would be expressly limited in scope. The reason for that is that the objector's subpoena request stated 3 different purposes, only 2 of which the hearing officer and I believe were adequately fled in the objector's petition. The first of those issues is whether the circulators did in fact circulate the sheets that they signed as the circulators. The second valid issue is whether in fact those circulators signed their affidavits in front of a notary. But the third issue, for which we do not think the subpoena should be granted, is what is stated in the subpoena request, is to inquire into whether the witnesses signed, to inquire whether they have engaged in a pattern of fraud. There is what purports to be a pattern of fraud allegation in paragraph 19 of the objector's petition. But it does not allege specifically that the circulators engaged in fraudulent conduct. It is based on allegations that they submitted signatures that were not signed by signers in their own proper person. And your submission of those signatures alone has not been grounds for finding having fraud by this electoral board. Similarly, it goes on to state that they submitted signatures of voters who are, or persons who are not registered voters. Again, almost all circulators do that. The case law says that when a petition signer holds himself out to be a registered voter, the circulators have no duty to inquire, to confirm that fact before they submit the photos. So almost every petition, dare I even say every petition perhaps that we've received has some voters on it and not registered. These actions alone are not a pleading of fraudulent conduct. And so therefore we don't believe that the objector has actually pled fraud. They haven't pled forging, roundtabling, and now they're trying to inquire into whether that has happened. They're not even in their request for subpoenas affirmatively alleging that it happened. They're saying they want to inquire to see whether it happened. That inquiry should have happened before they filed their charge.
Are there any questions? If not, is there a motion to deny the objector seeking a request for the stated purpose of determining whether the voter signatures on the witnesses' sheets were forged or round-tabled, as that purpose is not relevant to any allegation that was pled in the objector's petition, and to approve the objector's subpoena request as to all 5 witnesses for the limited purpose set forth in the subpoena request that are relevant to the allegations pled in the objector's petition. Those limited purposes being A, to ask whether the witnesses did in fact circulate the petition sheets on which they signed the circulator affidavit, and B, whether the witnesses signed said circulator affidavits before a notary.
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. The next case is 20 EDWC-019, Mary D. Olivo versus Jacqueline Baez, Ward Committeeman, 36th Ward, Democratic.
Here we have 3 subpoenas requested by the objector for the person who owns a home where the circulator reportedly resides, plus the candidate and that circulator. There is an allegation that the circulator does not reside at the address stated. The candidate did not contest the request, and the hearing officer recommends it granted.
Thank you. Are there any questions? If not, is there a motion to approve the objector's subpoena request for the individuals named in the request?
So moved.
Is there a second?
Second.
All in favor?
Aye.
Motion passes. We will now proceed to the consideration of hearing officer reports and proposed final decisions. And we have 2 cases where the hearing officer determined that there are valid signatures and recommended that the objections be overruled. And those 2 cases are 20 EB RGA-004, Xavier Vasquez versus Eva Dina Delgado, representative in the General Assembly, 3rd Representative District, Democratic, and 20 EBWC-020, Mary D. Olivo versus David Feller, Ward Committee Person, 36th Ward, Democratic. In both of these cases, the hearing officer recommended that the candidates have sufficient valid signatures and that the objections be overruled. Is there a motion to dismiss the objections?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and the names of Eva Dina Delgado and David Feller shall be placed on the ballot in March 2020 primary. We have 2 cases, we have 3 cases where the hearing officer determined that there were insufficient signatures and therefore that the candidate should be off the ballot. Those three cases are as follows. 20 EB WC-006 George Brown versus Cleopatra Watson, Ward Committee Person, 9th Ward, Democratic. 20 EB WC-011 Raymond Lopez versus Otis Davis Jr., Board Committee Person, 15th Ward, Democratic. And 20 EB WC-021 William Kelly versus Richard Gordon, Ward Committee Person, 42nd Ward, Republican. Is there a motion to adopt the hearing officer's report and sustain the objections?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and the names of Cleopatra Watson, Otis Davis Jr., David, and Richard Gordon shall not be printed on the ballot. We have one matter, 20 EB RGA-014, Tawana J. Robinson versus Justin Slaughter, representative in the General Assembly, 27th Representative District, Democratic, in which the hearing officer has recommended that the objections be dismissed for objectors' failure to appear. Is there a motion to adopt the hearing officer's report?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. The objectors' objections are dismissed, and the name of the candidate, Justin Slaughter, shall be printed on the ballot. At this point, is there,
Well, I would just like to state, for the record, Madam Chair, I have final decisions memorializing the actions taken here today for signatures. Pursuant to section 10-10.1, these will be served on any parties who are not present today by mail. They have 5 days from mailing to file a petition for judicial review. If there are any parties in the room, you may step forward and obtain your copy of service right here, right now. And then, Madam Chair, I'm also sending down the subpoenas that were approved by the board today for your signature. And that is all the electoral vote matters.
and at this time, I have not received a request for public comment. Is there anyone here for public comment? Is there a motion to recess at the call of the chair?
So moved.
Second?
Second.
All those in favor?
Aye.
We're recessed. Thank you.
Madam Chair.